Welcome to another episode of Pakistan Information, and today we will discuss the Contract Act 1872. Now, you may not have much experience in life with civil laws or criminal laws, but chances are that in your life you will come to a contract, any form of contract. It is the most common form of law, and it is also considered the most complicated form of law, one of the most major laws in the country. And it is not just in Pakistan, it is used in India, it is used in Bangladesh. They're same renditions, they're same forms. Now, this act came to be on 1st September 1872 and it contains 266 sections. Now, most students would often lose themselves by thinking there are 266 sections. This act is not going to be done by them. But this act can very easily be divided into several sections, and then through those divisions you can come to understand them, and I will use those divisions to help you understand them. Now, from section 1 to 75, these are general provisions. What are general provisions? From 1 to 75, this act is basically teaching you what is contract, how it can be formed, where it is void, where it can be applied. It goes from simple two-person dealings to dealings between merchants to imports. It utilizes those. Now, from 76, section 76 to 123, there used to be a section of sales of goods. But this was removed from this act. Another act was made, Sales of Goods Act. So that's 76 to 123 repealed. That's a lot easier to now go with the Contract Act. So from 124 to 147, these are indemnities and guarantees. So we have 1 to 75, that is basically explaining you what a contract is, when it can be void, when it can be used, when it can be fraudulent or anything like that. And from 124 to 147, you're getting your indemnities and guarantees. Okay? From 148 to 181, these are bailments and pledge. These sections deal with those only. And from 182 to 238, these deals with agency. And we will get to those. We will get to those as well. But for now, this is going to basically tell you what a contract is and how to understand it better. Because we can't delve into Contract Act without understanding what a contract is. From 239 to 266, there used to be partnership. But now it is a partnership act. They took that part out as well. So basically we have what? 47 sections removed? 47 sections removed, and 47 from sales of good, and 27 from partnership. So that's 47 and 27, that's 74 sections removed from 266. It's gotten a lot easier now. So without further ado, let's see where we can take this next. Made a bet with your friend that today Pakistan will win a cricket match, and Pakistan lost. No big surprise. So is your friend legally bound to force you to give him money? That since you made the bet, you wanted Pakistan to win, they lost? No. And this is where we need to understand what is a contract and what is an agreement, because we can't delve into a contract act without understanding what are these contracts and agreements. So first thing we need to understand is that all contracts are agreements. This is part done. All agreements of its forms are all contracts are agreements. However, not all agreements are contracts, and we understand this through their definitions. We understand this through their formations. You see, we understand, since the very definition of Contract Act in Contract Act for contract is section 2 subsection H, which says that any agreement enforceable is a contract, legally enforceable is a contract. Now, we need to understand and very easily remember what is the process for this. How do we go about it? So, to understand the process, we need to understand how a contract can be made. So, first of all, for a coming of a contract, there needs to be a proposal. Somebody has to propose something. Okay? Then that proposal has to be accepted. Now, what is the definition of a promise, which is the acceptance? Right? There needs to be a proposal and there needs to be an acceptance, and then there's promise. So what is the definition for it? Section 2E defines what is an agreement, and section 2b defines what is a promise. And I'm going to use a simple method. We're going to see a bit of a flow of it. Okay? Section 2b says when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. Now here, when I first read it in my school years, I got lost in proposals and acceptances. But it very simply says that when a person who has just received a proposal, he says that yes, I have approved, it is accepted, and that accepted proposal becomes a promise. You see, I previously said that accepted and promises are basically the same thing, and it does become a form of promise. So if anybody gives you a proposal and you accept, that becomes a promise according to 2b. So 2b says that it is a promise, and then it goes to 2e, where it says that every promise and every set of promise, if they have a consideration for each other, are an agreement. Now this is very important to understand. You see, we have next step is consideration. What is a consideration? It is that value, it is that service, it is that thing that you will do in return for that proposal. That for somebody proposes you that he will sell their house to you for 30 lakh, that's a consideration. That is consideration, and we need to understand that an agreement needs consideration. Contract needs a consideration, agreement needs consideration. And when that consideration made, an agreement is formed. Now section 2h says that when that agreement has legal enforceability, then it is a contract. So most students get confused, okay, what is legally enforceable? Where does enforceability come from? A major difference between an agreement and a contract is that agreements are mostly social in nature. They are not enforceable. For example, let's say that your father told you that he will give you a brand new laptop if you get first position. You get your first position, and then you're standing over there in your father's study, that where's my laptop? And he says, well, you know what, I'm not going to get you a laptop, I can't afford it. So can you file a case against that? Well, no, it's a social agreement. Contracts are legally enforceable. For example, let's say that you order a laptop from daraz.pk. The seller at the daraz doesn't send you the laptop. It's been 30 days, nobody comes in. Can you go to court to legally enforce the completion of that promise, which we will learn later on what remedies are available, or a return for the cash you paid? Yes, you can, because that's a legally enforceable contract. Now, the major distinction that we need to understand when we talk about legally enforceable is that these are aspects where the person, when he's giving his consent, and the person, when he's giving his proposal, have a legal mind towards it. All right, that they give it in a form where it becomes legally enforceable. It takes a legal form, it takes a legal aspect, and this is where we must understand that it gives rise to or leads to legal obligations, right? For example, a social contract does not give a legal rise, it does not give a legal promise. However, contracts of other form, of legal form, do. Another example of this could be that if you promised that when you will go to home, you will make chicken biryani for everybody, and in return they will clean the house. This is a give or take process, right? You get your consideration, you have your proposal, they accepted, everybody accepted it. So when you go to home, they clean the house, but you say, I'm not making any biryani. You see, that's not legally enforceable. They can't sue you, they can't take you to court, and this must be understood. So for this, let us see some differences between the two. What is an agreement and what is a contract? You see, the first difference between the two is that a contract is an agreement that is enforceable by law, but an agreement is a promise or number of promises that are not contradicting and accepted by parties. These are their definitions. Okay? With contract, first we have 2H, and with agreement we have 2B, right? So, sorry, 2E. We have 2E. You see, there's a process towards it. There's when I was in school, my one of my friends taught me the BED and the BEH process. All right, where you need to understand that BED comes from the forms of its all. Okay, what is so next difference between the two is that contract is only legally enforceable, whereas an agreement is socially acceptable and it may or may not be enforceable by law. For example, if you don't make biryani and everybody cleans the house, but you don't say, they can force you into that through social norms. However, a contract is only legally enforceable. A contract needs to have some legal obligation that you must do it. An agreement doesn't need a legal obligation. Now, next we must understand is that Section 10 of the contract actually, in a way, tells you what is basically required for a contract to come into place. And this is what we go around with general provisions. They go after explaining what Section 10 said. The next step, the next step, the next step, the next step. So, first of all, a contract must have a consideration. If it doesn't have a consideration, it is not a contract. If somebody asks you that they are willing to buy your car and there is no consideration, for example, he just says, I want to buy your car, and you say okay, and nobody gives a price, there is no contract. This is needed. You see, if you just throw him your keys, that's a gift, that's not a contract. Next, we must understand this concept of consideration, and it's not just for monetary consideration. It can be service, it can be, and service attribution is actually a very important part of consideration. A lot of contracts have service attribution. Next is lawful object. Another example I want to give is, let's say that a thief came to a servant and told him that at 10 p.m. you will open the gates and I will give you 10,000 rupees. Here is the 10,000 rupees. He takes it. 10 p.m. the thief comes. The servant doesn't open the gate. Can the thief take the servant to court? No, he can't, because the object of the contract must be lawful object. For example, I went to a drug dealer, I bought 10 kgs of cocaine, and I gave him the money. He ran off with my money. Can I file a case against that contract? Can I file against that drug dealer that he did not fulfill the contract? I can't. That was not a lawful object. He can run away with the money. An unlawful act is not a contract, so it is not enforceable by law. You see, through this we can understand that half of the things are getting cut. For example, any dealings where there is no consideration, that's not a contract, that gets kicked out. A thief comes in, that's not a contract, that's an unlawful object. For example, let's say that an enemy alien is another example. An alien person, that's another example. He's not legally competent to enter into a contract. So next step is, we need to understand is, what are competent parties. So a party that is not competent cannot have a contract. For example, I take you to Civil Lines Housing Society and tell you that, hey, I want to sell this house and for 50 lakh. Now that's a lawful object, it has consideration, but I don't own that house. I'm not a competent party. A minor wants to sell his house. He can't. He's not a competent party. So dealings of minors and non-competent parties, they get cut out. So that's three that we need. We need consideration, we need an object, a lawful object, and we need competent parties. Third, there must be an offer and acceptance. You can't have a contract without an offer and acceptance. It is needed. So somebody has to make an offer and has to make an acceptance. For example, if you leave your gate and somebody just throws money at you and tells you, I'm entering the house, he can't. And when you stop him, he can't go to court and say, look, I threw you 10 times the value of his house. That house is mine. They're gonna say, was there an offer? Did he accept? And if you gave him an offer, if you told him that you want to buy a house, he ignored you. There was no acceptance. Half of the contracts in contract law come to this question, whether there was an acceptance or not, whether there was a signings. Last is free consent. This is where half the cases are filed in contract law. Gee, there was no consent. Free consent is an important aspect because you need to be free consent. You need to have free consent. For example, if you're standing in your ATM and you have entered the pin, you're about to enter money, and a guy comes in with a gun. He points the gun at you, and he says that you're going to withdraw 50,000. You're going to give it to me. You withdraw it and you give it to him. He runs off. So that's not free consent. You didn't consent to give it. That's not a law. That's not a contract. He can't be caught by police and then say, we had a contract. He could have said no and I would have left. Another example, and a more realistic example, is that you don't want to sell your house, but a party forces you to sell your house. They come to you, they intimidate you, they threaten you, they threaten your family, and you sell the house. But you file a case in court that this contract was illegal. They had me tied up. They pointed a gun to my family. I had to sign those blank documents. So there comes free consent, and the court is going to say, fine, there was no consent. You can't have that house at all. So here we see that where there comes intimidation and frauds, intimidations and undue influence. Undue influence is another aspect. And undue influence is a very, very grey line from which half of the cases are fought at. And we will get to that later on. We will look at all of these because this is where general provisions are going to go. They're going to talk about considerations. They're going to talk about lawful objects. They're going to talk about competent parties. They're going to talk about offering acceptances. They're going to talk about free consents. They're going to talk about each and every one of them. Now, I'm going to give you an example. Let's have a fun example. Ali agrees to sell his house to Umar for 20 lakh. And is it a contract? Okay. Is there a contract towards it? So if such a question comes in, we need to look at those proposals. There was a proposal, there was an acceptance, and there was consideration. So with that, there is indeed, it is a contract. Why? Because Ali agreed to sell his house to Umar. However, here's the trick, and this is where it gets really funny. We don't see Umar's consent. Whether Umar decided it or not. Where was that? Ali is agreeing to sell his house to Umar. It's his house. Of course he's going to agree to sell his house. What's the role Umar played? You see, in such questions, a lot of times there's an option that they're neither a contract nor an agreement. And a lot of times that's the true answer. That's the correct answer. And we need to understand these because a lot of time in contract law questions, especially when we give LawGat and others, a scenario is fully made. A lot of times it is fully made and a lot of times it is half made. And we must look at each of this scenario through those. Was there a proposal? Was there an offering acceptance? Is there a consideration? Is it a lawful object? Okay? Over here we are getting a few of them. We are getting an acceptance, we're getting his house, and we're getting 20 lakh. We're not getting a proposal. So we're not seeing it. You see, if we're getting free consent, he agrees to sell his house. We need more information in such a case. And in such a case, a lot of times if there's no option then you can go with it. Yes, it's a contract. Otherwise, not a contract, not an agreement, not yet. There needs to be a proposal and there needs to be an acceptance. Now, this is very important part. A lot of students get it wrong and a lot of times they're pretty surprised about it. Now, I'm going to keep doing a lot of these videos on laws and on Contract Act. I'm going to do more of them and we're going to study more and more as we go into, because we're going to give time to general provisions. 1 to 75, these are not difficult. They're basically what I've shown you. This is basically the summary of those sections. They just go into explaining each and every scenario, each and every aspect of it. So have no fear. Always look into these aspects, whether there was any proposals, whether there was offers and acceptances, whether there was considerations. Follow those paths and then come to those where section 10 says what is a contract, how it can be formed, whether they were lawful objects, what the party is competent. So if you like this video, then I would like you to comment on it, And if you like it, if you really like the video, then you can click on the like and subscribe, because I'm gonna keep making more of these videos, and inshallah we will go upon this more road together. All right, goodbye.